Hello. Hello. Is my voice is audible? Hello. Hello.
Hello, Sanat.
Hello. 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 Your not voice is not audible in my device. Is my voice is audible here?
Yes, sir.
Sanat, it is audible.
Hello. Hello.
Hello. Hello.
Hello.
Sir, it is audible.
Yes, yes,
Can you
yes.
hear me?
I
Yes.
can hear. I can hear.
Okay.
Whether the quality of audio is fine?
Wait for a few minutes, Kenneth. Dr.
Uh,
Kenneth, please wait for a few minutes.
yes, yes, fine, fine.
We welcome Medical Superintendent of Ayurveda Medical College and Hospital, Dr. Lakshmi Shupadhya. We welcome you, sir. We welcome all the invitees participating from different universities, deemed universities, various institutions of different streams of nation, and their respected deans, HODs, faculties, PG scholars, UG students. We welcome respected doctors and dignitaries of government and private hospitals, private clinics, pharmaceutical industry people, IT sectors, law practitioners, etc. of different parts of our nation. On behalf of Department of Agada Tantra, NPI Medical College and Hospital, NPI deemed to be university. We welcome all the respected personalities of our NPI deemed to be university and its constituent institutions. We also welcome all the respected HODs, faculty members, consultants, and other staffs of NPI Ayurveda Medical College and Hospital. We wholeheartedly welcome each and everyone for this program on behalf of Department of Agada Tantra, NPI Ayurveda Medical College and Hospital, NPI deemed to be university. Welcome heartily, welcome to all of you.
It's my proud privilege to invite our most respected Dean of Enapoya Ayurveda Medical College and Hospital, Dr. Guriraja H., for lighting the lamp virtually and for the inaugural address.
शुभं कुरुत्वं कल्याणम् आरोग्यं धनसम्पदः शत्रुबुद्धिविनाशाय दीपज्योतिर्नमोऽस्तुते दीपज्योतिर्नमोऽस्तुते शुभं कुरुत्वं कल्याणम् आरोग्यं धनसम्पदः शुभं कुरुत्वं कल्याणम् आरोग्यं धनसम्पदः
I request our principal, Dr. Guriraja H., for the inaugural address.
Thank you, Dr. Sheetal. Respected Pro Vice Chancellor, Dr. B.S. Shripati Rao, respected Vice Principal, Dr. Sridhar Gokhale, respected Medical Superintendent, Dr. Lakshmi Shupadhya, and respected today's speaker, Dr. Sanat Kumar T., and organizers, Dr. Satyamurthy Kumble, HOD of Department of Agada Tantra, Dr. Sheetal Raj, Associate Professor, Department of Agada Tantra, Dr. Rukma Sikpe, Assistant Professor, Department of Agada Tantra. Today, I am very happy to say that Department of Agada Tantra has come out with a unique program in webinar organizing on the topic Consumer Protection Act in medical profession, a Boon or Bane, on the day of National Consumer Day. And it is a very different topic they have selected, in spite of selecting something related to treatment aspect or something related to disease. They have concentrated the consumers. Nowadays, you all know that the consumer is a king, and he has got all the moral rights to seek any legal opinion regarding any treatment he undergoes. I take this opportunity to congratulate them for arranging such a good program, and I wish all the best on this occasion. Thank you for the opportunity, and I wish students of our college and all the students and other delegates who are registered today to take the benefit of this webinar series. Thank you.
Now I request Dr. Rukma C.K., Assistant Professor from the Department of Agada Tantra, to introduce the guest speaker, Dr. Sanat Kumar T.
Thank you, ma'am. A very good morning to one and all. With my humble salute to Lord Dhanvantri, I would like to introduce today's eminent speaker, Dr. Sanat Kumar T. Dr. Sanat completed his UG and PG from Alva's Ayurveda Medical College. He started his teaching career from SDM College of Ayurveda, Hassan, and then joined the esteemed Institute of Medical Science, BHU, Varanasi, in the Department of Agada Tantra. He is a well-known Agada practitioner. He has attended and participated in many conferences, both national and international, held in various countries as delegate as well as speaker. He has delivered guest lectures on cumulative toxicity and non-compatibility disease management at SDM College, Hassan. Also delivered guest lecture on organophosphorus poisoning at JSS Ayurveda Medical College, Mysore. He has numerous publications in various reputed journals. His areas of professional interest are research in the field of drug toxicity, food toxicity, and Ayurveda in health tourism. It's a great privilege to have you, sir, with us. We wholeheartedly welcome you, sir. We are grateful to this virtual platform which has made possible to connect you residing far off in North India from the southern part of India. We welcome you, sir.
I request the delegates to mute the mic. Dr. Sanat, you can unmute the mic and start the presentation.
Hello, is it audible?
Yes, sir, it is audible.
अनेक जन्म संप्राप्त कर्म बंध विदाहिने आत्मज्ञान प्रदानेन तस्मै श्री गुरवे नमः. Respected Pro Vice Chancellor of NOPI deemed to be University, Dr. Sripati Rao sir, Principal of NOPI with the Medical College, Dr. Gururaj H sir, Vice Principal of the college, Dr. Sridhar Gokhale sir, respected my Guru, Dr. K. Lakshmi Shupadhyay sir, Dr. Shubhada madam, respected Professor Dr. Satyamurthy Kumble sir, Head of the Department of Tantra, my senior Dr. Sheetal Raj, Dr. Rukma, and other teachers and students and other participants. I'm thankful to all the organizers as well as the management for giving me an opportunity to share my limited knowledge with you. Myself, Dr. Sanat Kumar T, Assistant Professor, Department of Agada Tantra, Faculty of Ayurveda, Institute of Medical Science, Banaras Hindu University, Varanasi, going to present on topic Consumer Protection Act in Medical Profession, a boon or bane. As we know, the Consumer Protection Act 2019 was passed 9th August 2019, approximately 1 year, 4 months back, and it come into force since 20 July 2020. So directly we'll look into the what is there for a medical practice. What is the take on the doctors? Whether do they come under the ambit of Consumer Protection Act? If yes, whether it is a boon or a mere bane. That is what we are going to discuss in this presentation. The presentation will cover these subject matters. Coming to the introduction. So, service of doctor and other medical professional are virtuous and dignified. Saying Vaidyo Narayana Hari means doctors are equivalent to Lord Vishnu. So every medical professional start his service in the medical profession after taking the Hippocratic Oath. The Hippocratic Oath start with I swear by Apollo physicians, mean which necessitate the physician to swear upon the God that he will abide at most ethical standard in his clinical practice. The six ethical the practice like autonomy, beneficence means which doing good to the patients, non-maleficence which means not doing any harm, justice and telling the truth and remain faithful in the clinical practice as well as society. The right to health is the fundamental right of an individual recognized by our constitution. However, as a civil society, we fail to provide justification to this right. Technically speaking, the right fall on the state. That means the government realizing its limitation, providing optimal the justification, has started seeing as active assistant of the private sector, which is now about nearly 70% of our healthcare covered by the private health sector. In certain stage, however, instead of taking the private sector into trust, the government use its sovereign power. This has resulted many unfair practices being employed by a few private practitioners. I mean to say very few, not all. But the pandemic has exposed this dynamic widely. So the few has become many. So the state is supposed to play important role the regulating the sector, but it so far remained passive. So state intervention has been very minimal, leaving the sector to grow in out of control way. So role of medical associations or the medical council has been equally minimal. And if they intervene the case, so there is a cry that they having a or their role is biased. So there is the significant growing dissatisfaction with the service offered by the private sector and increase of medical negligence, which lead deterioration of the doctor-patient relationship. However, to curb this, the private medical practice, which was brought under the Consumer Protection Act since 1995. But once again, after this also the scenario didn't change, and deterioration of doctors-patient relationship prevail, as well as doctors started seeing the patient in a hostile nature. Coming to the law related to the medical practice, the Civil Procedure Code, Indian Procedure Code, Law of Contracts and Law of Torts. Under the IPC section 304A, where the doctor who commits criminal liability is punishable with the imprisonment for the term which may extend up to the 2 years, with the fine or a both. Coming to the civil liability, where it arises in the case of medical service rendered on the payment basis or the payment of fee under the section 73 and 74 of Indian Contract Act, where I do stress the payment of the fee, where in the case of free treatment, providing the treatment in a free of cost, which will not held the civil liability. Under the law of tort, the civil liability is applicable to the doctor on the ground of professional misconduct. So why CPA is required? The Consumer Protection Act was enforced in India as people were reluctant to avail the service of civil court, as the excessive cost, as well as long delay in the decision making, as well as the limited access to the court, as well as difficult to prove the negligence as well as causation. So consumer protection has been formulated to be a consumer friendly. So there is no very minimal the fees as per based upon the claim where claimant makes, as well as the person can plead their own case without the help of any counsel or lawyer. But the majority of the case we see in literature which is available, the lawyers are appointed to fight the case, as well as the decision would be taken within the period of 3 to 6 months. But there is no provision in the Indian Medical Council Act 1956 to entertain any complaint from the patient, as well as there is no provision to give the compensation in the case of negligence is proved. Then look into the definition of various component of the act. So who is the consumer in the medical profession? So a patient who pays to get the medical as well as hospital treatment, it may be promised to pay. So is about to pay the fee, or partly pay, or partly promised to pay also. What will be considered as a consumer. The doctors cannot say, I did the treatment, he is about to make the payment, so there is no consumer relationship with the patient. So legal heir means any relative who is related to the patient, who pays for the patient. Maybe the father is paying for the son is paying for the father, so they will also consider as a consumer. In the case of death of a patient, so legal heir or any relative will be considered as a consumer. So in the case of the any person who is not related to the patient, so he is making any payment for the treatment, as well as when any organization making the treatment or NGO is making the payment for the treatment, then they will be considered as a consumer. So this is about the definition of consumer. So what is the complaint? So any claim made by a claimant or the patient in writing. So it is very specifically in writing that the treatment or a service availed or employed used by the doctor or a health provider is anyway defective. So it should be in a writing form. There is no requirement of stamp paper or a stamp for filing the case, or mere a plain paper is sufficient with the details of the patient as well as the whatever his complaint it is. But the present new law, which gave the widest what opportunity for the patient, even a message or any email is sufficient to file the complaint. So who is complaining? The consumer or a patient, as well as central government or a state government behalf of the patient, or one or more consumer having same interest. In the case of any medical camp, they met with an untoward action of that medical camp, then the group of people can fight the case in a single case, as well as a person consumer had brought a television from a particular company, and all those people can come together and file and they can be considered as a complainant. Or any registered voluntary consumer associations like the Balakidar Vedike, which we have in around the Mangalore, so they can also complainant. So coming to the right of the consumer, a patient is entitled to certain amount of protection to be ensured by the physician, healthcare system as well as state. So which is codified in various societies in different countries in the form of Charter of Right. So first and foremost, right to the safety. So this act defines this right as a protection against the goods and service that hazardous to the life or property. For example, in safety of the medicine, the people are concerned about safety of the medicine. So pharmaceuticals as well as the untoward action of medical or surgical procedure. So where the right clinical trial or the pharmaceutical trial or as well as skilled medical practice could minimize any such dysfunction. So right to information is where where patient need to know informed about the quality and quantity of the surgical procedure or the price of the procedure. Or in a clinic, there is a rule that we have to enlist the consultation fees in a first sitting, second sitting, and dressing charges. There is a rule, so it is the right of right to information of the patient. So as well as when the price of the product and should be informed to the patient when the implant is used for a surgery, an orthopedic surgery case, where the different the price should be explained to the patient, and which what stent or which implant is used for the treatment, it should be explained to the patient. So it is a right to the information. Coming to the right to choose, where consumer has all the right to choose with the different products, different type of a management. He may opt a conservative management for the individual ailment where surgery is also option. He may opt a alternative system of medicine when the modern medicine system is available, or he may opt a individual priced a product instead of other product, which is when he given the options. So the where the patient have multiple option, and it is his right to choose what treatment have to undergo, what is the consumable which should be used in the treatment. And right to heard is the purpose of right to ensure the patient to get due recognition in the consumer code, where his voice will be registered, and his complaint will be registered, and that will give a motivation for or it will empower the consumer to fearlessly voice and concern and seek justice in the case of if he is exploited. And next right is right to seek redressal. Here is about the right to approach the consumer court, where a patient or a consumer feel.
Excuse me, sir.
he-
Excuse me. Sir, your PPT is not visible. So please put it in presentation mode.
Can you see it right now?
No, it's not visible.
1 minute, 1 minute.
So please click the present now once again.
Yeah, yes, I'm doing that.
Okay. Sir, it is visible now.
Yes. So, right to seek redressal, here it's about right to approach the consumer court when the patient feels he is exploited. It's not the treatment or a surgery is not met the level of expertise which could have reached. So then he can approach the consumer court and file case and seek the compensation for exploitation. So last right is right to consumer education. This speak about right to educated about the medicines, pharmaceutical and medical and surgical procedure by expertise in the field. So consumer also has the confident choice about the goods and services where or a patient who undergo the therapy. This is about the right of the consumer. So the Consumer Protection Act 2018 as well as 2019, where So definition of service, under section 2/42, the where the healthcare is included. You can see healthcare is included here, but in the in 2019. വീട്ടില്ല Is it audible right now?
Yes, sir.
Yes, sir. Yes, sir.
So in the 2019 draft, the healthcare system was removed from it. The term healthcare system is not nowhere is can be seen in the subsequent draft. So which create confusion in the in the medical field as well as patient, whether the medical profession is included or not included. So this create here there are argument as well as counter argument. And
Sorry, invitees, due to some technical problems, you'll be joining soon.
ഡോക്ടറെ ട്രൈ ചെയ്യുന്നുണ്ട് രണ്ടാമത്, അത് കണക്ഷൻ ലോസ് ആയി. ഹലോ, കേൾക്കാമോ?
It's audible.
ആ.
Please join as soon as possible.
So can you see the slide right now, madam?
Now it is clear. Now it is clear.
The slide is available, no? Slide is there.
Yes, the slide is there.
I will continue. Wait.
Yes. Thank you.
So, sorry for that inconvenience. So the argument is, it is not mentioned nowhere in the you can see in the slide the consumer protection the under the definition of service is not mentioned. So however the group of doctor can say it is not there in under the ambit of services, but the counter argument is under when counter argument number 1, look into the description of the service. The service of any description which made available to a potential user and include but not limited to. Please do remember a particular emphasis, but not limited to, which give the wider scope to include medicine and healthcare system into a definition of service. Hence, it is there under the purview of Consumer Protection Act. Coming to the counter argument number 2, where it has excluded only 2 things. That is, one is rendering of any free of services, free of charge, and contract of personal services. That means personal service, that means servant and master contract. If you have a cook at your home, you are paying salary for her cooking. So you cannot file a consumer case on her. So there is no consumer relation with the servant, and she is not a service provider, and she is the rendering of free of service, which is in the free of cost, as well as contract of personal service is excluded. But nowhere in the definition you can see the exclusion of the word health or healthcare system here. So it is healthcare services included in the purview of Consumer Protection Act. So coming to the third counter argument, where in old 1986 draft did not include the healthcare profession in the under the ambit of Consumer Protection Act. Subsequently, in 1995, a Supreme Court judgment on the case of BB Shanta versus IMA is a landmark judgment, where it brought the medical profession with the ambit of service defined in the Consumer Protection Act 1986. So it is since then the many judgment came from the court saying the consumer protection is about the consumer protection and inclusion of healthcare system in that. So the court clearly says that any so whether a term exists or not, the way we saw the healthcare term is not there. So whether term exists or not, a consumer who has offered a service has all the right to approach the court. So if he come to a hospital, it is a service to a patient on the contract basis. So and if he is having sufficient evidence of breach of duty or any medical negligence, so he can approach to the consumer court. So the role of doctor in CPA, where the apex court clearly says the relationship between the patient and the medical professional, it is a contractual nature. Remember the word, the contractual, as well as hence a patient who had sustained injury in the course of treatment can sue the consumer, sue the doctor in the consumer forum for a compensation. So coming to the counter argument number 4, where we'll discuss about the deficiency. So deficiency means any fault, dysfunction, or shortcoming or inadequate in the quality, nature, and manner of performance, which required to be maintained by a person in a pursuance of contract, maintained by a doctor in a pursuance of contract, otherwise in the relation of the service. So if doctor failed to do the thing, or and his action lead to any deficiency, or in action itself come under an imperfection, then he will come under ambit of Consumer Protection Act. At the same time, the deficiency, it clearly mentioned that any act of negligence or commission doing any mistakes, omission doing any necessary, not doing any necessary thing in the treatment, in the due course of the treatment, then such person which caused loss or injury to the patient, or so it also fit under the Consumer Protection Act. And deliberate withholding of any relevant information, so it come under right to information. So if the patient is not provided with the required information, then the doctor will fail to give information, or a doctor is not taking the informed consent, then whole deficiency come into picture. So all these fit into the Consumer Protection Act. So coming to the argument number 5, where mediation rule, which says under the rule number 4, the matter relating to proceeding in the respect of the medical negligence resulting in the grievous injury and health should not be referred to a mediation cell. So in the new draft, which says you can instead of consumer forum, you can go for a mediation between the two party. But it is very clearly says that any grievous injury means fracture or loss of vision or a loss of hearing or a loss of sexual vigor due to your treatment, then will be considered as a grievous injury, as well as death will not be come under the ambit of mediation. So the medical negligence come under the ambit of Consumer Protection Act. So the counter argument number 6, where the definition of the consumer. So once again, I am repeating the definition of the consumer, which says the two important things. One is buying of any goods or hire of any service, where a patient also who hire the as well as avail any service, which include maybe in the form of the direct selling or a direct communication with the doctor, or any online matter, maybe online consultation, will also attract the Consumer Protection Act. So there is no doubt that counter argument is very strongly state that with the support of the court judgment or many other judgment clearly state the doctor-patient relationship is contractual, and hence it will attract the Consumer Protection Act. So coming to some difference between the old draft and present draft, the Central Consumer Protection Authority, which is formed in the new draft, as well as in the Consumer Court, the locality of the Consumer Court, where he can find the case. So in the present, if you take service in a Varanasi, you are going back to the Mangalore, and you can file a case in Mangalore. Earlier it was not like that. As well as the product liability also include in the present consumer draft, as well as the fine, the precautionary, the jurisdiction, which is increased drastically, more than 5 to 10 fold it is increased. So doctor, we should be very careful about in our clinical practice regarding the consumer protection aspect. So where the district forum used to fine about 20 lakhs, which is increased more, up to the 1 crore, as well as state forum used to fine about 20 lakhs to 1 crore, which is increased to the 1 crores to 10 crores, which is more than tenfold, about the tenfold. As well as national forum used to fine about the 1 crore, which is increased to the 10 crore. So it is an alarming bell to the doctors who is practicing in private, who is doing the private practice, as well as not only the private practice, even government, the practice higher centers, the government center also liable for it. And the e-commerce is included, as well as mediation rule also included. So what is the new in the Consumer Protection Act? So one of the most significant addition of Consumer Protection Act 2019 is proposal to establish the Consumer Protection Authority, where it will regulate and investigate or protect and enforce the interest of the consumer. So it has provided with a vast power to inquire, investigate, take action against the violation of the Consumer Protection Act 2019. And another important, significant power which is given to the CCPA is the power to take and impose penalty against misleading or a false advertisement, which we come across daily basis. Even our product also, like Lavana Taila, anything like, they are misleading the society. So any such advertisement will be endorser as well as the company will be liable for such misleading advertisement. Maybe we see so many film stars or so many cricket stars who is coming for the endorsement. So for them also it is applicable. This rules is applicable. So CCPA impose penalty of 10 lakhs for a first violation, and about 50 lakhs in a consecutive subsequent violation of the it may be a fine the collected from the manufacturer as well as the endorser. So in addition to that, if manufacturer and endorse may be sentenced for the up to 2 years also, and they have all the right to take action and impose penalty against the misleading as well as false advertisement. And the very interesting the one inclusion is we pay more money for a food in the multiplex. So they also come under this particular the CCPA. They also come under the Central Consumer Protection Authority. So as we know, the 3-tier system is the Consumer Protection Act is there: district forum, state forum, as well as central forum. And the district forum is presided by the district judge or a retired district judge who is appointed by the state government. The state forum, which is presided by a high court judge and appointed by the state government. The central forum, the presided by the Supreme Court judge or retired Supreme Court judge who is appointed by the Supreme Court. All the three, the forum should have a women representative, as well as the 2 other members should be there in a district and state forum. The national forum can have 4 or more other members. Here, Dr. feel it is unfair to have a non-technical person or a non-legal person or a non-medical person who can be a member in this particular forum. So they can have their own thought process, or their voice or their vote also very important in the case of deciding factor. So these are the location of a consumer forum. Then comes to the liability. All the medical practitioner doing independent medical practice, unless rendering a free service, are liable for a medical negligence. Then they can liable for a Consumer Protection Act. All the private hospital charging for the patients, as well as, very interestingly, all the hospital having free as well as paying patients. So where the category of patient is not collected with any fee, and another category of patient where the fee is collected. In the medical college we see that. In those aspects, the service extended to the free patient also will attract liability to the doctors. So because their treatment is funded by the other source, like the paying patients. So the hospital is receiving the fund from the payment patient. So once again, these 2 categories also come under the liability, as well as medical practitioner and the hospital paid by the insurance firm. Nowadays, we can see the more and more the claims are, even Ayurvedic treatment also attract the insurance claim. So any such hospital which take the payment from the insurance firm, as well as in the case a employee who is employing in the hospital itself. So any negligence can be in the treatment which is extended to him, which is if it go wrong, then he may be not paying any bill in that hospital, but also his treatment will liable for a medical negligence. And how liability arbitration carried out. So the complaint which is received in a writing form or in an email in a present scenario, as well as the forum can accept the complaint, as well as the forum can send the health provider written note, and he should reply within the period of 30 days in a written form only. And after receiving the written response from the respondent or a doctors or a hospital, so proper scrutiny will be done with the interrogation professional testimony and medical literature as well as judicial ruling. So earlier there was no need to come to the court and presence was not required. So later it was included, even the what online or what telephone conversation or conferencing is sufficient for attending the court. So when proof is found and if it is satisfy the court and the allegation made by the complaint, made in the complaint and on medical service is proved, then it can issue the order like fee waiver, compensation to the consumer, as well as the correction surgery or the subsequent second surgery with the free of cost. And there is a provision of appeal within the period of 30 days. One can appeal against the order, as well as the state district forum case can be appealed in a state forum. The state forum case can be appealed in the national forum, as well as national forum case can be appealed in Supreme Court. So what are the time schedule for a complaint disposal? So every complaint will be decided within the period of 90 days on the date of receipt of notice by the opposite party. Where there is a requirement of the testing sample, then additional 5 months will be given for a further investigation. So appeal will be disposed within the period of 90 days. If the complaint or appeal resolved after the stipulated time period, then forum or commission shall record in the writing the reason for the delay. So there are some terms of the Consumer Protection Act. So limited period is there. So we cannot file a case after the period of the 2 years. I cannot, the consumer or a patient cannot file a case after the period of 5 years. As well as if the cases are or the complaint is found the vicious, false, as well as frivolous, then the court has all right to dismiss and order will be given. He should give a sum of the payment not exceeding the 10,000 rupees to the opposite part, maybe a doctor. But the present 2019 draft, above mentioned fine, which is the 10,000 on the frivolous complaint, has been removed, and it is the major concern for the doctors, and it may increase the possibility of frivolous cases also. And the penalty will be imposed if doctor or the claimant fail to obey the order. So imprisonment for the term which not less than 1 month, which may extend to the 3 years. If doctor failed to give the compensation or obey the court order, so he may be sent behind the bar for a period of 3 years. And fine which is not less than 2,000, which may extend up to the 10,000. Additional money may be charged, or with the both. And the consent, whether the consent is a tool to avoid medical negligence, can it be used? The consent is voluntary agreement or a permission for a specified act, purpose, or any treatment, which can be gained from the patient or a patient party or a parents or the guardians in a different stage of the patient, different stage of the treatment. On admission, one set of consent is there, and when the case is found very critical, then high risk consent can be taken, and the critical patient sent to the surgery, another set of consent can be taken. And when during the surgery patient met with a cardiac arrest, and another high risk consent need be taken. So it can be taken in a stage wise. It might be the implied consent as well as oral consent, which is not having much legal value, but it can also it can be crucial in some of the conditions. But the oral, written informed consent play important role. But having said that, in a particular case, a patient undergone septoplasty under the consent lead to the breathing difficulty due to the blockage. Whether you can take as a stride, you can take it as a granted. I had taken the consent from the for a surgery, so which could involve the certain amount of the risk. But having said that, your action or your treatment should not hamper the normal function of that person. So where the hospital found guilty, as well as the compensation is given to the party. And as well as another case of Mr. MGK versus Dr. AO of Kerala, where during the C-section of a placenta previa, it is a complicated condition, there was uncontrolled bleeding, and the emergency hysterectomy was done and performed with the oral consent of the parents. And the husband, after a few days, the husband filed a case against the hospital. So they didn't took any informed written consent in this particular case. And the court examined, did not hold the doctor as liable for negligence, because to save the life of the patient, this action was very much necessary. And even though the court took the expert opinion from the other hospital to before coming to the final judgment. So consent, if you say it is a tool to avoid the negligence, yes or no, it will once again create the confusion. So where it is based upon the scenario, once again the consent may be the consent role come into existence. And in order doctors are innocent or a duty, and in order to achieve the success in the action for negligence, the consumer must be able to justify the law of code that the doctors owed him the duty to conform a particular standard of professional conduct, as well as the doctor was derelict and breached that duty, and the patient suffered actual damage, as well as the doctor's conduct was directly responsible for the cause of the damage. If any failure to provide substantial evidence on any such element may result in no compensation. So coming to the duty of care, when a doctor charged with the negligence must be shown to have under duty of care to a person complaining of negligence. In the case, if doctor is not available in the hospital and patient rushed to the hospital by assumption that this doctor is giving excellent treatment for a particular complaint, and by that time doctor was not there, and patient died in the emergency ward itself, but the doctor or the hospital and where the duty of care will not be it will not attract the duty of care. The relationship of the doctor and patient can be formed very easily with a mere implied consent or a oral consent is sufficient, and no means of depends on the formal assent of patient by the doctor. And the fact that no payment is offered or are expected to make payment make no difference of a duty of care. In the case the patient is about to make the payment, and in that condition doctor cannot say that he is about to pay the payment, there is no duty of care. But in the case of good Samaritan doctor who helped the roadside accident victim, not bound by a duty of care. In the case in a roadside accident, doctor will not be equipped with all the required consumable or any instrument to serve the patient. So in that condition, he is not liable for a duty of care. As well as any the examination which is not for the treatment or other than the treatment, then he'll be then there will not be such a liability of duty of care. For example, in a military parade, examination is done, or in an employment parade, the examination of patient is done. In those conditions, it will not be liable for an insurance purpose. The examination of the patient is done. So where the doctor is not liable of duty of care. Coming to next, the dereliction of the duty, where the failure of a doctor to honor his duty that is owned by his profession, or it may be the act of commission, where doctor failed to give a TT prophylaxis in the case of any injury or prior to a surgery or prior to delivery, and these are the dereliction of the duty. And when doctor failed to reach a standard of proficiency expected from him, then it will attract the dereliction of the duty. And once again, here a confusion arises: the fresh doctor or a newly appointed doctor would not expect it to have a similar proficiency of the skill and like of senior specialist. So there are the difference of opinion even in the court of law also. Some of the judgment which say the fresh doctor is not liable, but the final judgment of one of the cases, it says if doctor is not giving the basic required treatment or required examination, he failed to do the required examination of a particular case, then he will be liable for a dereliction of a duty. So where dereliction of the duty will not stand. So in a case of State Consumer Dispute Redressal Commission of New Delhi received a complaint that modern management of acute pancreatitis, which would include laparotomy, removal of necrotic part. Now, laparotomy means opening of the abdominal wall, removal of a necrotic part, and intensive care, which was not followed in a particular case, which resulted in deterioration of the condition. And however, the patient approached to the court where the commission did not hold the doctor negligent, because as a recognized different school of thought which advocate the conservative management of acute pancreatitis, also a role of a manner of treatment in the condition of acute pancreatitis, where the nasogastric aspirations done, oral nil by oral is done, antibiotics is given, and other medicine IV intravenous, the nutrient is given in those conditions. So that is also one of the manner of treatment. So as recognized, different school of thought will not attract dereliction of duty. Next is damage, which is referred to injury to the disability suffered by a patient. So when doctor failed to exercise the duty of care, must lead to the actual damage in order to which is actionable, where it should be proved that the breach of duty was a real cause of damage. In such damage was reasonably foreseeable and is part of history. Other detail will be examined while examining the damage, whether this damage was due to his previous history, or with this damage it is due to the present treatment which he undergone. So in the case of Mr. Khanna versus RJ Stone Hospital, so complaint of pain abdomen, and that found that it is due to the prostate issue, and Mr. Khanna is advised to undergo a surgery, and subsequently he underwent it, and later he met with a very rare complications like leaking of urine through the rectum, and he once again approached to the hospital, and the hospital said it will cure its own, no need of any further treatment for it. As he is not satisfied with the answer, then he approached another hospital where he got a similar answer, and subsequently it got cured its own. But when he approached the consumer forum, and the consumer forum thoroughly examined his the past history as well as his case, and it is found that he was positive for retro, that is HIV, as well as he was a diabetic patient too. Then due to this, he might come across a state of immunocompromised. So that lead into a perforation and a rare complication which is occurred, and the court dismisses that particular case. And a term damage refers to a monetary compensation that is intended to restore the injured patient. However, it may not expected to restore his wrongly amputated limb, or it could compensate for the loss of wage in the case patient who can no longer do his trade. So some of the terminology in the negligence, where the calculated doctrine of calculated risk doctrine, in certain procedure where there may be a certain amount of inevitable risk. So in those cases, the charge of negligence will not stand against the doctor if proper care is given, even the prior treatment and post the incidents also. In the case of amniocentesis, where it is always associated with the 1% risk of abortion, where the gynecologist will not be held responsible of negligence as it is inevitable in nature, as well as the another next terminology is novus actus intervenus, where it applies in a situation where cause of injury or death transfer from the initial event attributed to the doctor to subsequent reckless behavior in some other person. So here, a case like a patient, a person who had a assault or a stab injury, then he brought to the hospital where he met with a reckless treatment procedure, which was not expected from a doctor, and he died. And it is very difficult to prove whether he's died due to the previous incident or whether he's died due to the negligence which is happened in a hospital. So the next is res ipsa loquitur, where the things speak for itself, where it is very clear. So the amputation of the wrong limb, which is visible visible in anywhere. So where the doctor or a hospital authority or the nursing attendant may miss to mark the proper limb, as well as mark the tooth in the case of extraction of tooth. So which may once again liable for the criminal negligence, where the patient may file the case against it. So next aspect is the professional secret. So that is which doctor comes to learn in the confidence from the patients on examination or investigation. So doctor have no right to divulge any such secret other than a certain agencies like the privileged communication, where doctor can communicate with the court of law, or doctor can communicate with the police, or a doctor can communicate with the government regarding his complaint, which should not spread to another person. So the record should be maintained period for 3 years. And there are these two cases related with the hospital record, where in the Kanyalal Trivedi versus the Satyanarayanan Vishwakarma case, the hospital and doctor held guilty for deficiency of service, as record was not produced before the court to refute the allegation of lack of standard care. So in another case like the Dr. Shyam Kumar versus Ramesh Bhai Harman Bhai, where no producing of record to the patient to prevent the patient party seeking the expert opinion, where right to information is right to information is avoided here. So in these two cases, where the doctor held guilty for not giving the proper care about the document as well as hospital record too. And the next is the professional misconduct. The 6A we should avoid in our clinical practice. That is the illegal abortions, adultery, means having any relationship other than the treatment with the patient. Then the consumption of alcohol in the duty hour whenever attending the patient, and addiction of any drug or any addiction of any narcotic during the duty of care, or advertising already discussed. But there is a provision for advertisement for a doctor in the commencement of his practice, when he changed the address, when he got any new the degree, additional degree, then there is a provision, but it should be in a specified manner. It cannot given in a big manner, but hospital are given permission to give the advertisement in a bigger manner. So as well as last one is association with the wrong person, association with a quack person, association with a non-legible person for a treatment or a medicine. Maybe association covering his complaint also lead to the professional misconduct, may attract negligence as well as it may attract the consumer protection litigations. So doctor should not do any illegal things like the performance of illegal abortion, and doctor should not issue the death certificate where cause of the death is not known. So when a patient brought to the hospital in a state of broad dead condition, so you don't know what is his history, and you don't know what was the event he come across before his death. So you cannot issue a death certificate in that condition also. maybe if patient died at home, the patient party may ask for a death certificate. Then it is only the responsibility of the treating doctor, or who know his past history, can give the death certificate. As well as there is a provision to give the death certificate in broad dead condition. It is only, you should specifically write in the certificate that this certificate is issued for only for preservation of the dead body, not for any legal issues. And next is the not intimating the police in the case of accident, in the case of burns, in the case of suspicious death, in the case of assault. So there is a prescribed format is available in the hospital to intimate the police. So which include the doctor's name, his place, address, where he met with the assault, by whom he met the assault, and his identification mark should be recorded, as well as left thumb impression should be recorded. If doctor failed to do the such intimation and cover the incident from the legal matter, then he is liable for the negligence. And not calling the magistrate to record a dying declaration. It is one of the critical in a critical condition where the patient want to reveal something with a proper through proper channel like magistrate. Then the doctor should facilitate the thing for should inform the magistrate and record the dying declaration, as well as unauthorized, unnecessary, uninformed procedure or treatment, which will also lead into medical negligence. So coming to a case where it is a very interesting case where the patient sue a dentist for a botched treatment, wins about the 60,000 rupees relief. Here the patient went for a root canal treatment at Bangalore, and she met with the untoward incident, like the improper drilling was done, and she met with the infection of sinus, infection of the tooth, and pus formation is witnessed. And when she took the second opinion, and they said it is improper because of improper drilling. When the scanning is CT scan is done, the improper drilling, and the doctor who charged only the 3,000 rupees for a root canal treatment, and he forced to shell about 60,000 rupees for a small negligence, as well as the patient claimed, I want 10 lakh rupees for the relief, but the court issued only the 60,000 rupees by examining the all the aspect. So another case where the journalist, a famous Bofors, we all know the Bofors scam. The journalist who is famous for the Bofors the case revealing, so she sued a private hospital for a negligent case where they employed a different implant rather than which was shown in the prior to the surgery, and that is lead into a life-threatening cancer like multiple myeloma. She met with a multiple myeloma. The hospital was sued for it, but the other details are not available. So the doctor should act according to their skill. So doctor should not hesitate to take any second opinion. Doctor should not hesitate to take any help from the other doctor, especially in the condition like on the assault or a stab injury, the surgery when surgery made in the stab cases, or in the case of just like atonic uterus where the profuse bleeding is happening. In that condition also doctor should take a help from the another doctor, as well as a surgery where the patient the patient's vision or a patient's the sexual function in danger. In those conditions also doctors should take or the help from other physician. And in the case of Ayurvedic therapy, where we give the basti in our in IPD sector, IPD patients. So prior to going for basti, we should go for the anorectal examination or opinion from the Shalya Tantra department. So in order to prevent the further complication, if there is a case of the patient already suffering a complaint like the fissure in ano, or he had the hemorrhoids, so this will lead the further complication. So we should act accordingly, as well as because we should have a genuine concern for the patient. And informed consent or proper consent also play important role in the case of treating the patient. Coming to the prevention, we know prevention is better than the curing. So the prevention is the doctor should possess the approved qualifications, as well as that qualification has its registration should be displayed in his clinic. And doctor should not give any guarantee of treatment or a curing of any such conditions. And proper communication is play a very important role in our clinical practice, especially in the emergency. The emergency ward should be attached to kill with the equivalent qualification and in similar circumstances. And last one is a social aspect, where doctor she should take care of a patient, even the patient party, through a proper expression, proper body language, and action and discussion. So the body language play important role. Even the corporate hospital, if you see how they behave with the patients, so they appoint a certain people manage the patient also. So that also play a very important role to avoid the such the means the patient satisfaction is important. However, the result it is, you should satisfy the any event to the patient party. So you should convince the patient if the patient indemnity. So if your clinical practice, your hospital, it is covered with the insurance, that insurance may cover or provide claim of compensation awarded against the doctors, and insurance may give a sense of mental stability even in the case of negligence. And the insurance may cover, or it will be helpful to arrange the advocate for the legal help. So it is also very important. It is need of we should see for such kind of the professional indemnity in our clinical practice. Prevention by the people supporting group. So it is the societies as well, societies to provide the social security, societies which will a regular fellowship that prohibit the doctor speaking foul against their own colleague. So when we talk about our own fraternity, so it give more motivation to file a case against him. So we should restrain from such kind of activities. Last is the boon of the Consumer Protection Act in a medical professional. So there will be always a clinico-pathological meet in the instant of even the medical negligence also. So that will improve the knowledge of a patient, so that we can avoid the medical negligence that may result in the consumer protection litigations. So there is a big list of Bane. The Bane is having majority over the Boon. So which is very painful for us, as the medical the field is highly technically oriented, and which will give the wide scope of for filing the case. So the doctors says that the medical service should not be compared like a defective household appliance like TV, refrigerator, etc. And we know the declining of credibility of medical field because of one reason is the professional jealousy is there. This tool may be used as for the professional jealousy, as well as and declining of the credibility of medical field. It is once again because of the excessive commercialization of the medical profession, and this will turn into a bane to the doctors. And inclusion of doctor under the act, which encourage the frivolous complaint, or the corrupt lawyers, they encourage the frivolous complaint, as no fine is charged here. I already explained, no fine is there for the false complaint, as well as we have a lack of education in our country. Illiteracy still it is in a high state, as well as people are suffering with a low socioeconomic status. This may prevent the patients from the filing the case also. So where the patient is going to lose here, as well as because of lack of trained staff, there may be medical negligence may happen. Due to lack of trained staff, there will be inept but medical record keeping may happen, as well as the corrupt lawyer may go for exaggerated claim, as well as the doctor will be harassed for a arrest for corruption will be seeping, as well as the last and foremost, the growing urge of the defensive medicine. So it is a biggest issue where the patients are ultimately the loser. So doctor will not make the doctor will not take a treatment of a patient even with a slight complicated ailment. So in a smaller area, if you find a smaller hospital setup, if you find a complaint of MI, and soon after the ECG, he will send to the bigger hospital where the avoid such kind of cases. And in a bigger hospital, what will happen? They may go for a unnecessary or a mini test will be employed in order to it may produce abundant in order to the precautionary measure, we may not go for a medical negligence. So there are some of the suggestions from the medical field. So court should have a power to examine a complainant, say a patient with the oath. So in another court, we see the oath is there, but here the oath taking is not there. So the consumer court should be able to grant a compensation to a defendant in the case of the false claim, or a court should be screen all the complaint. But the present scenario, it is not like non-professional people can be a member of the consumer forum, as well as only the president of the forum. He is having a legal background or a judicial background. In the case of opinion, so opinion of a majority will prevail. So doctor saying we should include the fraternity of medicine for seeing the cases. These are the suggestion for a CPA. And coming to the conclude, with the Consumer Protection Act, the medical profession may seem to be vulnerable, but it forces the medical personnel to be a more responsible, accountable, remain update to serve the society in more efficient and effective manner. So as it is the need of the hour. So as it is an alarming bell to the doctor forever, we don't know when the new law will come, which could relax doctor furthermore. But the present scenario, the more freedom is given to the patient in the new bill, or more the freedom is given to the consumer. As some of the recent judgment of a national forum, it is very shocking that they say the method of the consent taking in a hospital itself wrong. Say that we where the pre-printed form we are collecting the consent. The doctor, where the patient's name and doctor's name, diagnosis are written in a blank space, and other detail will be furnished. So they say the national forum gave a judgment that it should be a different in a different condition. So so even that too question the consumer by the consumer all the authority giving an opportunity to present my presentation. Thank you one and all.
Gaining knowledge is the first step to wisdom, and sharing it is the first step to humanity. I thank Dr. Sanath for sharing his knowledge with us. Now, the session is open for questions. Delegates can unmute the mic and ask questions, or you can type question in chat box. Already there are some questions in the chat box. So I will read the first question. When a patient dies while some procedure is going on, what should be the verdict on the doctor? And what are the things a doctor should take care of?
So once again, the duty difficult to manage in that condition. So here the duty of care or duty of care which is extended the post of later to the condition, later of the incident, and what all the what precautionary measure which he took before the procedure. That also very play important role. There was a case when we are studying it in my post graduation. We saw one case at Mudbitri, where the 33-year-old lady met with a massive cardiac arrest in an OT table in an ENT case, where it is a inevitable condition, but the doctor held responsible for her action, but later it is proved that there is a provision that calculated risk doctrine, which I already explained. So where the doctor will not be held responsible for a vasovagal reaction, but the society as well as media, it see it in a different from the different aspect. In a subsequent newspaper there was a the heading is "Moogiಗೆ surgery, ಪ್ರಾಣಕ್ಕೆ ಕತ್ತರಿ." So no one is ready to listen the whatever the doctor is saying, and his voice is nowhere heard in the society. But this consumer forum, they even see the calculated doctrine, calculated risk doctrine. Hello.
There was another question, that is, if a child died during his surgery and the reason for the death of the child is not clear, but the surgeon committed a suicide later due to defamation, is it possible for the legal heir to file complaint against the person or people who caused defamation that led to his suicide?
So in this particular case, the case of suicide, proving of a case of suicide, it is very difficult even for a stringent medical system. And the case, whether case is filed against the society, who is the society? Whether you and me will be included in the society? It is not possible. It's not possible to case against a particular society. But if you have a significant proof against a particular person, or maybe the patient party, they started spreading the news that it is because of him, this doctor, my child is died. In that condition, or any social media, the communication can be used. So used for for fighting those cases. So there is a provision, but you cannot fight against the society. But you can fight against the individual who is responsible for such kind of communication and such kind of the blacklashing of a doctor. And in those conditions, it is possible. But in the case of defamation, it question like the being a professional issue of law, and only the proper step prior and post action will help the doctor in such cases also. So it is possible to file a case against an individual or against a particular group of people, not against a society.
There is another question, and that is, how to substantiate Boehm's test with respect to Consumer Protection Act?
So I already, I think, come across a case which is related with the Boehm test. In the case of, I already shown in the case of acute pancreatitis, where the hospital held not held guilty, not doing the standard protocol which is performed by the different school of thought.
And if the patient does not know any of the languages, how can this be done?
So it is entertained in the written manner only. It is entertained with the written manner only. But he can hire a lawyer for the same, for filing the complaint. In present, no one is writing the case in a white paper and submitting in a court of law or in a consumer forum. It is submitted through the affidavit. It is submitted through the a counsel only. So he will help him if the person is having any issue, or if he is not sound enough, the court will help him in order to write the case or file the case against in a writing form. But nowadays, the new improvement is we can mail the complaint also.
So another question is there any need to sign an agreement by the patient at the time of admission to the hospital?
Sorry, can you repeat the question?
Is there any need to sign an agreement?
We see signature of the patient where the risk involved with the treatment should be written below the consent form. That it is in a contract. It is in a contract between the patient as well as doctor, and the medical negligence case always arises when there is a lack of information which is passed to the patient party or patient. So when you are having a proper information passing to a patient party, then no such issue will raise. But the patient's doctor relationship, it is a contract, and doctor are bound to follow this contract and extend the treatment according his skill which is available.
Okay, there was another question, and that is regarding the need of Consumer Protection Act due to an already existing Medical Council of India and State Medical Council, and that is well answered by
Dr. Sheetal. Can I have a word?
Thank you, sir. Thank you for sharing your knowledge and experience with us. We lost our connection in between. Sorry for that. Now I invite Dr. Rukma CK for the vote of thanks.
Good morning. Gratitude is the fairest blossom which springs from the heart. I take this opportunity to wholeheartedly thank our speaker, Dr. Sanath, on behalf of Department of Agada Tantra, Yenapoya Ayurveda Medical College, for sharing his valuable knowledge on the topic Consumer Protection Act in medical profession. Thank you, sir, for this enlightening presentation and for taking out time from your busy schedule.
Thank you for opportunity also.
Thank you, sir. Next, I would like to this webinar, without whom this event couldn't have been successful. I would like to thank all the participants from various parts of India from the bottom of my heart. Thank you all. And also, I thank all the teaching and non-teaching staff and our beloved students who were involved in this webinar.